So that being the case, the taxpayer instructed that and was advised that an urgent application be drafted, and the basis of that urgent application is really divided into two parts. The first part, one has to convince a court that the matter is urgent, and in this particular case, the matter is urgent because SARS is on an ongoing basis really traipsing over the rights of this taxpayer by denying them the right to legal representation, by not giving them adequate reasons, and then thirdly, by having intruded their rights to privacy in the most intrusive manner, really by using a steam hammer to crack a nut, which is a very famous quote by a well-known English judge, Diplock. You do not use a steam hammer to crack a nut. And a steam hammer was not required here. What they needed to do was to exhaust the first two avenues of obtaining that relevant material from the taxpayer. That being the case, urgent application was drafted, and the grounds of urgency was the actual ongoing encroachment of the taxpayer's rights, where the taxpayer is being severely prejudiced, and in that regard the court is asked to interdict SARS from carrying on this abusive and wrongful behavior towards the taxpayer. The second part of the application is then heard at a later stage, and that is where the court is asked to review the unlawful conduct of SARS, in particular those three areas again, but the most important one being the fact that SARS had intruded upon the rights of the taxpayer in the most intrusive manner, when in fact there were two lesser intrusive manners available to them. And you remember I gave you the two cases that are relevant to that particular principle earlier. The leading case there for the purposes of tax I mentioned to you was Ferrucci versus SARS 65 SATC 47. So where the matter stands at the moment is the application has been drafted, launched and served on SARS on an urgent basis to interdict SARS from continuing with this unlawful behavior, and the second part on that interdict being granted will then be a review application down the line. This application, Part A and Part B, is brought in the High Court, and you'll recall that in terms of Section 105 of the Tax Administration Act, you have the right to bring these matters to the attention of the High Court, and this is one of those instances where the attention is brought to the High Court, and the reason for this is that the main thrust of the argument is that SARS's conduct in terms of Section 2 of the Constitution is inconsistent with the Constitution and therefore invalid. In order to have it declared invalid, you need to bring it to the attention of the court, and so in terms of Section 172 of the Constitution, you need to then bring the appropriate application, and this is the appropriate application that I've just described to you. I have also drafted 10 questions to just test your knowledge on the content of this lecture. I think that's enough from me for now. This is Professor Daniel Erasmus signing off, and just by way of final note to you, those of you who have an interest in this particular area of law, please take a look at www.iitf.net, www.iitf.net. I actually teach a year-long online part-time course on an advanced diploma in tax procedural law dealing with this type of issue. And in addition to that, if any of you have any further questions, please do not hesitate to contact me at daniel@taxriskmanagement.com. That's one word, daniel@taxriskmanagement.com. Or you can telephone me on 083 45 88 422. 083 45 88 422. This is Professor Daniel Erasmus saying thank you very much for listening. Until next time, goodbye.